I'd like to call the Senate Special Task Force on all aspects of liquefied natural gas to order. I'd like to just first quickly introduce the members of the panel that are here. As I indicated prior to us going on the air, having a necessity of trying to put these together very rapidly, I was unable to do so in a total accord with my colleagues' schedule. So these colleagues who are here today, some of them are actually holding off on other events and matters that they have obligations to, and so they may be leaving, but I want to thank them for being here. And as I mentioned before we went on air, they are all going to be getting DVDs of the proceedings so that they have an opportunity to review. And again, just because we were trying to do it so rapidly, there was a little problem with making sure I accommodated all the folks who wanted to be here. I would like to introduce some of the folks who are here, beginning with the far left. Senator David Bates from District 32, Bristol and Barrington. Senator Frank DeVol from District 18, which is East Providence. Immediately in front of me is my friend Walter Felag, District 10, Tiverton, Warren, and Bristol. He virtually surrounds me. He used to represent my town. Used to be the senator for my town. To my far left is Senator Rhoda Perry from District 3 in Providence. To my immediate left is Senator Louis DePalma, District 12, Tiverton, Middletown, Newport, and Little Compton. And to my immediate right is Senator Joshua Miller. He is representing District 28, which is Cranston and Warwick. My name is Charles Levesque. I am the senator from District 11, which is Bristol and Portsmouth. And joining us is my friend, my old rep friend, Senator Harold Metz from the great city of Providence. The first person I would like, or organization I would like to call to the area to give testimony would be the representatives of the Coastal Resource Management. And I will ask you when you sit, particularly for the cameras, to identify yourself and your relative position, and then we can proceed from there.
Thank you, Mr. Chairman. I'm Brian Goldman. I'm CRMC Legal Counsel.
Grover Fugate, the Executive Director of the CRMC.
And actually, neither of you need any introduction to this body. Again, you are aware of the purposes of this committee. I see that perhaps you are prepared to go forward, so I would ask you to address the Commission on what issues you feel are pertinent to our discussion of the liquefied natural gas proposal.
Thank you, Mr. Chairman. Hold on one second here. We thought what we do is I just briefly give an overview and a procedural posture of the litigation that took place on the Weaver's Cove situation, and to just sort of set the table as to what procedural was going on. And the Executive Director, Grover Fugate, will deal with the actual application and the decision-making process that went through, that the agency went through. And then if you're indulgent at the very end, if I could just summarize what the findings of the court were very briefly, and really what the implications of that going on down the road, if that's acceptable to you.
I believe that's an appropriate. If nobody has any objection, I would ask you to proceed in that fashion.
Okay, thank you, Mr. Chairman. Procedurally, there were essentially two issues that were at issue in the litigation, and the first is what's called federal consistency procedures, which I'll describe briefly in a minute, and second was the extent to which the Federal Natural Gas Act preempted state authority to review LNG facilities. Briefly, federal consistency is something that's unique to CRMC, and federal consistency is authority delegated by the federal government pursuant to the Federal Coastal Zone Management Act to states that have a federally approved coastal management program, which is what CRMC does. If a state plan is approved by the federal government, in this case, which would be NOAA, the National Oceanic and Atmospheric Administration, States have the ability to review direct federal projects, such as activities taking place on military bases on federal property that you normally wouldn't have, as well as projects that require a federal permit, such in this case would be FERC, the Federal Energy Regulatory Commission, or the Army Corps of Engineers, as examples. And you determine, and under the consistency authority, you get to determine whether or not that federal project or those permits are consistent with the state's enforceable policies in the coastal plan. This authority is in addition to any state authority which the legislature has given to the agency under Rhode Island general laws. The main distinction between the consistency authority and the state authority is that federal consistency determinations pursuant to agreements with NOAA are made by Grover, the executive director, and that they don't go to the Coastal Resources Management Council, and that's pursuant to policies that NOAA has set up pursuant to the CZMA. Under the federal consistency procedure, an application is not processed or not deemed to be complete unless the applicant has provided the agency with all the necessary data and information. And once the application is deemed complete and has that necessary data information, it triggers a 6-month review period where the consistency authority has to concur or object to the proposal. If the applicant does not provide necessary data and information and is notified by the consistency authority that they have not provided the necessary data information, under the federal statute, the 6-month period is tolled. And that was essentially what the issue was in this case. In this case, when the application came in, and Grover is going to get into the details, he as a consistency authority, along with the staff, made a determination that the application was missing essential information that was necessary in order to process the application, and therefore the 6-month review period never started. Weaver's Cove, on the other hand, took the position sometime later down the line that it had in fact given the necessary data and information, and that the 6-month review period had essentially passed and had not gotten a decision. That was that was the first issue that was dealt with in the litigation in the district court and the First Circuit. The second issue that was dealt with in the litigation was the extent to which the Natural Gas Act, as administered by FERC, preempted the ability of states to assert state authority over LNG facilities. And with that table setting, Mr. Chairman, I would pass it over to Grover, the executive director, to explain the application process and the decisions that were made.
I want to interrupt because we will be coming back to a discussion about that issue. I do also want to remind everybody, and I am not suggesting you're long-winded, but I have promised my committee members to hold these meetings to roughly an hour and a half and no further. So therefore, I will, at times, perhaps direct somebody, hopefully nicely, to move forward with their discussion. I also want to recognize that I have been joined by my colleague, Senator Mike McCaffrey from the great city of Warwick, and also Senator William Walaska, also from Warwick. And again, we will proceed now with Mr. Fugate, and thank you.
Thank you, Mr. Chairman. When the application came in, one of the things that I should just explain to this body is that the federal consistency authority that's given to us is inherent within federal permits, as Brian also indicated, with direct federal activities, and per this chart, OCS, or Outer Continental Shelf activities, as well as federal assistance, that is federal funding, has to be consistent with the state's approved program. But relative to this particular application, each application that comes in, and in this state, it would be anything that involves a in-water activity, let's say it's a pile driving dock or LNG facility, all require both a federal consistency review and a state permit review.